Hey there, my name is Joseph Jones, and I'm going to be evaluating Priceline's terms of use or terms and conditions. If you ever clicked yes on accepting a website's terms of use, you most likely made the mistake of not actually reading them, even though you just consented to them. I'm one of those people that joins a website or program and does not read the terms of use because I don't have the time to look through all the legalities at the moment I'm using the site. Most likely, I'm only trying to make a purchase on an e-commerce site, but not every site asks you to have a profile with them. Even if you're on a website and haven't signed the terms and conditions that includes the privacy policy, the site can still try to say that you've consented to their terms and conditions just because you're using the site. You might as well have just shot yourself in the foot if you're a business that says, we have the right to change our conditions at any time, but we'll post the update eventually on our website for your awareness. Fantastic. Thank you so much for informing me that even though I joined, or maybe I didn't, your site, that you will change your conditions that I probably didn't read without my direct consent. At least provide me with an email or something associated with communication so I can be aware of such a change. As a business and a user, terms of use can be a challenge in a variety of ways. This is one of them. The one thing I can say is that you need to be very clear on what you're associating your business with in your terms of use. I want to be clear on what terms and conditions actually means. Business Dictionary describes them as general and special arrangements, provisions, requirements, rules, specifications, and standards that form an integral part of an agreement or contract. So, they are the key rules that must be followed according to that website. Now, I want to move on to Priceline. After reading their terms and conditions reluctantly, I've concluded the following. The contract of Priceline is only valid if both parties, the business and the consumer, the visitor, agree. In this case, me being a visitor and not agreeing to the terms already would mean that I have not consented to them, and therefore it isn't binding. Oliver Herzfield's article, Are Websites' Terms of Use Enforceable?, describes more of a terms of use situation with the court case of Schnabel versus Trilegient Corporation. According to the case, Schnabel was a member of Trilegient's online service, but never agreed to new terms of use that were added after his agreement of the original terms of use. In order to consent to a contract and make it binding, you must first accept the terms of use through either a button to checkmark or another means. Both parties must agree. So I've not yet agreed to their conditions and therefore am not held knowingly misconducting myself on their website. That goes against their terms. The differences of being a member versus being a visitor are known as click wrap and browse wrap. Click wrap refers to acknowledging and agreeing to the terms of use by clicking that shiny button. Browse wrap is for those visitors who reach the site and are browsing around it and haven't fully consented to the agreement. Websites that have browse wrap agreements typically are the ones that see lawsuits. This is due to the expecting too much of the visitor in regards to reading the conditions created by the website. Click wrap agreements are seen as the more trustworthy and safe agreements that save online businesses because at least the user had the option to read the terms of use and they did click the shiny button of I accept. According to Chas Rampenthal's article, your terms of use might be illegal. The company Zappos had their terms of use agreement struck down by the federal court because they were going by a browse wrap agreement. The reason that I would be able to sue Priceline is because they have a browse wrap agreement, because they never increased their inclination for me to agree to their terms of use. There is no increased notice. Terms Feeds article, Browse Wrap versus Click Wrap, clearly discusses the difference between the two agreements as needing to bring more attention to the terms and conditions for acceptance rather than just having a link to find somewhere on the page. Priceline doesn't have enough prompts to make me accept their terms and conditions, not even when you try to sign up. So this means that I can sue them because they don't have enough bold output. The terms themselves seem to be fine, though some are arbitrary in context, in what they request of users. Section 1 doesn't request any irregularities that would cause for concern, unlike what some companies have tried to accomplish. There was actually a test done for how many people would agree to the terms of use without looking through them. This is described in the podcast recorded article by Shankar Vedantam called Do You Read Terms of Service Contracts? Not many do, research shows. Surprisingly and ironically, people agreed to using their firstborn child as a payment method to a fake social media program. One out of over 500 people actually decided to have a cause for concern about this just because they were reading the actual terms of service. This is exactly why it's important to look at an agreement when you join an online service or website. Luckily, this was just a test conducted with a fake media outlet, but it still caused for concern. To be safer and to protect themselves from lawsuits by users, I would suggest pressing for a more for agreement by the user. Honestly, to be transparent, please be conspicuous and extremely obvious in trying to get users to mark that checkbox with a big X or whatever it may be, because it will only save future problems from occurring. This is my evaluation of the Priceline.com's terms of use. Thank you for watching this video, and I hope you're now able to understand my viewpoint about this topic and what Priceline's terms of use means in comparison to other terms of use. Thank you.